Hey, welcome to today's video. I'm Richard Chapo. I'm an attorney in San Diego, California. And today I wanted to go ahead and talk about the California Consumer Privacy Act because we have a potential CCPA amendment, and that's AB 1760. So, the CCPA is, of course, the California Consumer Privacy Act. It was enacted in the summer of 2018 under unique circumstances. It's often been compared to the GDPR in Europe. The GDPR took about 4 years to be drafted, negotiated, and enacted. The CCPA underwent that entire process in 7 days. So we didn't have any hearings, not a lot of lobbying, not a lot of negotiating regarding the text, not a lot of time to really think about the text and how it would interplay with other laws and what have you. They just slammed it right on through. And so there are all kinds of problems with it, regardless of whether you're pro-privacy or anti-privacy or pro-business or any of those positions. There are just a lot of inconsistencies in the law. And so we seem to be sort of having the legislative process now, and it's coming in the form of amendments. So in September, we had SB 1221 that was put forth to fix quite a few of the errors, and it in fact passed and was enacted and updated the CCPA. Now, there are a number of different bills out there floating around that seek to make other changes to the CCPA. Some of them are minor. Some of them are significant, and AB 1760 is significant. It would radically change the CCPA and turn it from mostly a California concept into essentially, I don't know if mirror is the correct word, but much, much closer to what the GDPR requires. The GDPR is the privacy regulation in Europe. It was enacted in May 2018, and it is very draconian. You have to have a legal basis for collecting personal information. You have to go through an endless number of steps about this, that, and the other in relation to compliance, notifications. This is why you're seeing all the pop-ups for cookies on sites. If you're actually in Europe, you see even more of them, and you also see pop-ups for collecting information for newsletters and things of this sort, and it's all just a bit of a mess. And so that's basically what AB 1760 is looking to incorporate. In fact, it would even change the name of the law. It would go from the California Consumer Privacy Act to the Privacy for All Act of 2019. Why do they want to change the name? I have no idea, but they do. We would move to an opt-in process for personal information collection versus opt-out. So currently under the CCPA, you can go to various groups and have the option to opt out of having data collected and, more importantly, having your data sold. And the AB 1760 would switch that to a scenario where companies would be unable to collect any personal information from you, even your IP address when you land on their site, to a situation where you would have to consent to all of that. So you would if you think about your favorite websites, when you visit them, there would be all kinds of pop-ups. You would have to go through the pop-ups and consent or not consent to various data collections. And once you get done with that, you'll probably have forgotten why you came to the site anyways. Other aspects of it, there'll be tougher disclosure obligations for companies. Companies will be required to disclose specific third parties that they're sharing information with. Again, this sounds like a good idea at first glance, but the people drafting these laws don't really seem to understand how the internet works. They're viewing only sites like Google, who are almost solely enclosed digital environments. But for most sites, if you think about a WordPress site, for instance, it may use, 5 or 6 plugins. It's using outside vendors for things like analytics. So maybe Google Analytics, maybe an outside vendor like YouTube to show videos. And so you would end up having to list all of these and essentially obtain data processing agreements from each of them. Places a massive burden on business, and quite frankly, only serious privacy advocates would ever read any of this stuff. And so the question is just about how effective is this really going to be in a real world environment. And then there are other requirements basically that just sort of mirror the GDPR as you go along. One of the big ones would be opening or expanding the ability of individuals to sue under the law. Currently, the California Attorney General is really the primary party enforced or authorized to enforce the the CCPA in many instances. Private individuals only have the right to do so under scenarios where there is a data breach, aka somebody got hacked and your information was exposed. Now, I'm sure the plaintiff's bar will challenge that, but nonetheless, that's how things currently stand. So it would be a significant change. Now, who's behind this? Honestly, I don't know. But it's interesting that a letter was sent in, and a number of internet companies, signed on to the letter. Now, most of them are small companies you never heard of, but one is DuckDuckGo. DuckDuckGo is a search engine that has a unique selling position, and that position is we don't collect or monetize your personal data. Which, the unsaid statement or the unsaid aspect of that statement is unlike Google. So DuckDuckGo is competing directly with Google. And, so the fact they signed on to this bill, while you would like to think it's because they have a strong feelings about privacy, I'm sure the fact that it would do damage to Google's business model wasn't even remotely part of what they were thinking about. So, the good aspect of AB 1760 is that if it is signed into law, while it's gutting the CCPA, it will actually move the enactment date for the law to January 1st, 2021. And in doing so, it's very interesting because the parties promoting AB 1760 may well have tripped themselves up. Right now, we have many, many different states in the United States that are enacting their own privacy legislation. And the vast majority of that legislation all has different requirements. And sooner rather than later, it's going to become nigh impossible to comply with the requirements of every different state and every different law. And so there's an expectation that at some point here, Congress, that lovely group in Washington, D.C., is going to have to get off their rear ends and actually create a U.S. national privacy law. Now, when they do that, under the Supremacy Clause, all those state laws would be trumped. No pun intended. Essentially, the national privacy law would be the binding law, and the state laws could go pound sand. Now, it's expected that we probably wouldn't see a national privacy law until 2020 at the earliest, maybe late 2020, or certainly because we have an election coming up after that in 2021. So the AB 1760, although if it was passed, I'm sure its backers would be very excited and DuckDuckGo would do a victory dance. The fact that the enactment date is January 1st, 2021 suggests that AB 1760 might have a short lifespan because I'm pretty confident that the U.S. national privacy law is not going to be a match of the GDPR. I would be very surprised if that was the case because I imagine the big tech companies, as well as data brokers and a lot of interested parties are going to be coming out in force doing all they can to prevent that. And there's going to be a lot of money spent in that regard. And personally, I hope they win because the GDPR is a bit much. So anyways, that's it for the potential CCPA amendment, AB 1760. Keep an eye on it. You can even commit a Google alert devoted to that phrase, and you'll see how it rolls through the California legislature and see how it comes out. So thanks for watching. Have yourself a good one.